venture partners in order to deliver a successful project. By way of introduction, for those of you who don't know me, I'm Tom Smith. I'm a partner in the the construction engineering dispute resolution team at Hogan Lovells in London, where I do international arbitrations, court litigation, adjudication, mediation, all relating to kind of large, complex energy and infrastructure projects. I also spent 3 years in-house as international counsel at a large Japanese heavy industries company, where I advised them on a whole string of energy projects across Africa. So I've kind of got experience on both sides of this, both as a external legal advisor, but also as the counterparty themselves, although hopefully, not one of the counterparties who are letting people down. So I'm joined today by an excellent panel, who have got a wealth of experience in this area. First of all, I would like to say that I am delighted to say that we are joined in person today by Abimbola Akeredolu, senior advocate of Nigeria from Banwo in Ighodalo. I'm sure Abimbola will be familiar to many of you here today. And I just want to say that we are very, very lucky to have been able to prize Abimbola away from her very busy caseload to join us on stage today and share some of her insights. Moving to the screen, we are also joined by Sena Gbedemah, Senior Managing Director in the Construction Disputes and Advisory team at Ankura in London. Sena is a delay expert with experience advising on and providing expert evidence in relation to major infrastructure projects across the world. He's got particular expertise in oil and gas and renewables. Next, and also joining us via video, is Emilio Kinde Arias. He's a managing engineer from Exponent with over 20 years of international experience in geotechnical engineering and engineering geology, working for consultants and contractors on the management, planning, procurement, design, and construction of large-scale and complex infrastructure projects. And then last but not least, we also have Mushtaq Namadarkhan. Now, Mushtaq is a partner at Mauritian firm BLC Robert, who are the co-sponsors of this panel together with Hogan Lovells. And he is a dispute resolution expert with a particular focus on insolvency and the enforcement of arbitral awards. So Mushtaq is a very good person to know when things get really tricky. Right, what are we going to cover in this session? Well, as the title implies, what I would like to get into with the panel today is the kind of particular difficulties of managing a poorly performing counterparty, whether that be a JV partner, as we were hearing about just earlier, or perhaps a critical subcontractor. And this is because large energy and infrastructure projects, they're kind of complex beasts. They require you to work really closely with a wide range of stakeholders, including employers, JV partners, key suppliers, and subcontractors. And most disputes tend to arise when these kind of what can be quite fragile relationships break down. Perhaps your counterparty is not performing as they should be. Maybe there are delays on the project, which is causing tension between you. There may be a lack of resources or perhaps issues with the quality of the work that's being carried out. And this session is aimed at looking at practical ways for you to address those types of issues or to advise your clients on how to address those issues. And it's going to set out what information you need to collect, the steps you need to carry out in order to minimize the risk to you and your counterparty, you and your company rather, when a counterparty lets you down. So in particular, what I'd like to focus on is the kind of quite a typical situation where you find yourself stuck in the middle. You or your client is, maybe part of the EPC contract JV. They have the pressure put down on them from the employer. They also have key subcontractors below. They may be fighting claims both below and above, and that leaves you in a very, very difficult position of how to manage that. So if I can turn first to Sena. Now, Sena, as an expert regularly instructing these types of large infrastructure construction projects. Is this kind of stuck in the middle situation something which sounds familiar to you?
Thank you, Tom. And first up, it's a pleasure and an honor to be here today. And yes, the answer to your question is a straight yes, indeed, very, very familiar. We've already heard today how many projects are multi-party. They involve funders from many institutions and sometimes governments. The different funding arrangements, they're brought together to work closely while they have different cultures, and they engage under a multitude of contractual arrangements and funding arrangements. And of course, all of this is there's a background of different cultures and different ways of working. And we've already heard today about how it can lead to financial instability. So yes, it all leads to fragile relationships, which means that the relationships can break down. An example on one project I was involved on recently was where a European operator owner commissioned European design house to conduct feed design, and a few years after the feed design, then commissioned an African local contractor as an EPC contractor, and the EPC contractor had to effectively, the African contractor had to form an EPC contractor with the European feed designer as to prepare the detailed design as part of the EPC. And of course, this is a forced marriage. They'd never worked together before. They've been brought together on this project. The European feed designer had never been to the location, never been to Africa, in fact. And of course, that could lead to different expectations. They both had different ways of doing business, and it's not surprising that they often result in disputes.
Thanks, Sena. And Abimbola, I mean, disputes between JV partners, you must see those all the time.
Thank you, Tom. My gratitude for being here. Speaking to your question, Tom, yes, it's fairly common, especially with concession agreements by government entities, given by government entities to private entities over an area of land or over a government asset. I've had a case where it was a piece of land, there was a development lease construction agreement, and another one was a terminal point for an airport. And well, I'll just speak to those two. What you tend to find is government will grant a concession to a private entity to use the area of land for 20 to 25 years, 25 to 30 years typically, in return for rentals from the project over the period of time. And the one case I've been involved in recently, the concession agreement was signed, concessionaire moved to site, and while constructing, the state entity showed up and more or less frustrated the contract. The state entity who showed up we operate a federal system, so the asset was a federal asset. Now the state government entity showed up and said you hadn't gotten the requisite approvals, and we're into the 15th or 16th year of that contract, and the concessionaire has not been able to put one brick on another. He's just been able to pile, and that's where they've been locked up in litigation for past 10 years, and that's strictly litigation. And the case of the concessionaire is that the federal government agency should have gotten all of the approvals, but the federal government agency is saying, but that's yours to do. So this is a letting down that has occurred because there was no consensus and a thorough analysis of the agreement as to where the rights and obligations fell. Another case where I'm representing the concessionaire, in that other case, I'm representing the federal entity. So there's a huge debate on there. In another case, now I'm representing the concessionaire, who's a transport company. In conjunction with another government agency, the plan was to create a cable-propelled transit project to alleviate, and it's here in Lagos State, to alleviate the transport situation, provide an alternative. It turns out that the state government appeared to have given the same concession over the same area, a different concession over the same area of land to yet another private company. We've been locked up in litigation for about 5 years now. And all of this has impacted adversely on this alternative means of transportation that the government should be putting in place. Another one was at the airport, where the project started and the state entity came back and asked that, look, you need to relocate this piece of land. We have another project coming on and we need to use this piece of land. And luckily they were able to settle. But the impact of that settlement, I think, is still being felt. It was a settlement, but I don't think it went very well for the federal government agency. And the impact is still obvious for all to see at the airport. I'll stop there so I don't disclose too many secrets.
No problem. Well, I think it's an excellent illustration of the way that these types of disputes between counterparties and JV parties can turn up right at the very outset of the project, and potentially just frustrate, as you said, even a brick being laid. But as you move on from that kind of initial kind of process, and you get into the execution phase of the contracts, you can also have all kinds of problems in and amongst your JV partners and your other counterparties. And this can cause real problems for the ability for the EPC contractor and for the owner as well to successfully complete the project. Now, generally speaking, we see kind of two main areas of disputes on these big projects during the execution phase. I mean, one is a defects and poor quality works, and the other is delay. Now, I want to take those in turn, and we're going to have a look at some of the issues that arise amongst the counterparties and how we might manage those going forward. So I'm going to turn to Emilio now. Emilio, if we kick off with the question of quality, is there anything that the parties can do at the outset of the project to try and mitigate the risk of defects or poor quality works causing delay and disruption later on?
First, good morning, or it's good afternoon now. Thanks for the invitation, and thank you, African Construction Law, for organizing this event. Obviously, poor quality or poor workmanship and defects is one of the main reasons for delays and cost overruns. And to put it in the context of Africa, several authors suggest that the defects and poor quality contribute to a big portion of the region's claims and disputes. In my opinion, the front end stage, even before tendering, is a very important stage for the successful completion of a project. Because this is the time when developers and sponsors of the projects have the opportunity to plan for all the risks and uncertainties, and there must be sufficient time allocated to this stage, because some of the root causes of defects are due to poor workmanship and skilled labor, poor quality of materials, defective equipment, and those risks or those causes could be not prevented, but at least mitigated at this stage before starting the project. Obviously, firstly, by using the right method to select the contractor of the project for the project. Obviously, but not considering price as the main factor, and also by using the right contractual framework. But yeah, if we move to the construction stage, I also think that quality monitoring during construction is very important. And although we see that quality plans and quality management plans are usually included in the technical specifications of many contracts, in my opinion, and with my experience as working on site and also as expert witness, those plans sometimes are not implemented correctly, if you like. And I think that this is in connection with lack of conviction by both parties, because they believe that quality systems are just another piece of paperwork or some kind of red tape. And sometimes it's due to lack of resources. And I think the owners, they have an important role on this, and they should understand the need and the benefits of quality control. And the quality control should start from the outset, even before construction, by setting the bar high and demanding of the contractor to prepare good quality pre-construction documents, such as method statements, risk assessments, because this is something I see again and again, and there is a clear relation between poor quality of this pre-construction documentation and the problems during the project. Basically, because the standard is not set high enough, and everybody in the project start to think that the quality plan is just another box that needs to be ticked. So, in summary, obviously defects are going to occur, but the employer should have a procurement route and a contract that mitigates this risk as much as possible. And during construction, quality plans must be followed completely, and the quality team on site must be resourced according to the size of the project.
Okay, Emilio, just picking up on something that you just said then, I think you said, defects are always going to occur. So if defects are inevitable in that way, what's your view on how risk for defects ought to be allocated at the outset of the project? So who should be bearing the risk for that? Should it all sit on the contractor all the time?
Yeah, I don't think there is a clear answer to that, because obviously there are many variables. It depends on the project. It depends on the type of owner. For example, the risks in a solar power plant are not the same risk as, for example, a hydropower plant in the middle of nowhere with a lot of uncertainties about the geology. And also the risk appetite of a government entity is different to a private funder. You can have lenders involved. So I don't think, Tom, there is a rule of thumb, because each construction project is unique. However, what I think is really important is that there must be owner's recognition of the project risks and uncertainties at the outset. I think this is very important. And also, I think that for certain projects with high uncertainty, like tunnels or hydropower plants that I mentioned before, for example, it's not sensible to allocate all the risks to the contractor using EPC contracts. Owners and funders, they like EPC contracts because they feel they have some certainty as to time and costs. However, in this type of highly complex projects with a lot of underground works, to think that you will be able to anticipate the duration and the cost of the construction, I think is not realistic. And I think it's wrong for the owner to think that they can simply just allocate the risk to the contractor and forget about them, because the risks eventually will appear somewhere. They will come back to you. Ideally, what the contractor expects, or what the owner expects, is that the contractor will price the risk. But we all know that what frequently happens is that the winning contractor has not really priced the risks, because that's what they want to do. They want to win the contract with a view of hoping for the best instead of planning for the worst. And when problems happen, and they will happen, this put a lot of pressure for the site team. And in turn, they put completion time and price over quality, leading to defects. So yeah, not an easy answer, but I think the best way is to be honest about your risks, and also be honest about how the price of the projects, because there are no easy ways to avoid the risks, and passing them to the contractor won't be clever in this type of projects.
Big lessons that we've had over the last, 2 to 3 years is that trying to anticipate what risks are out there and who should bear those risks only works with risks that you know about. And things like COVID-19, or even the kind of huge spikes we're seeing in material prices caused by a combination of COVID-19 and also what's been going on in Ukraine. These are the types of unanticipated risks, which is really hard to plan for. And when they hit your project, even if you've kind of attempted to allocate those risks within your contracting structure, sometimes you need to reallocate them, because the person who's bearing that risk simply cannot bear that risk. And the impact of that is that you may have contractors struggling, going out of business, or just refusing to perform in the way that you need them to, because they cannot bear the amount of risk that has flowed down to them. Just picking up on the COVID-19 piece of that, because we're still seeing kind of a big tail of projects heavily disrupted by COVID-19. Sena, just turning to you in your capacity as delay expert, can you provide us with any kind of advice or insight into the particular challenges of documenting claims relating to delay and disruption from COVID-19?
Yes. I based on what I've seen, the initial claims around COVID-19 related to site lockdowns, or in certain cases, whole countries being closed for business, and in those circumstances, the claims were quite simple. The site was shut, no one was doing anything, everything on site was delayed for the period of the shutdown, whether it was the site or the country or whatever, and everything resumed on starting. That then led to a middle period. There was a middle period when the COVID claims that we were seeing were related to new ways of working, where governments or sometimes industry bodies, like for instance in the UK, had passed regulations, new government directives on safe working distances, which impacted certain site activities and indeed impacted certain sites as opposed to other sites. So for instance, buildings were more impacted because the workers were closer together, whereas a linear site like a railway line, which was outside, or a road which was outside, was less impacted, because however, those linear sites could have been more impacted by the travel restrictions that were around at the time. So it really depended on geography by geography. It was at the more complex end. The projects at the more complex end were the ones that seem to be impacted by the long tail that you talk about, Tom. And indeed, many in the oil and gas area, or I've got a power station in West Africa, for instance, that I'm working on, which was subjected to several COVID claims. And those claims were characterized by either shortage of materials or materials being held in certain countries, like, for instance, en route from China, as an example, and being held in Dubai as an example, and not being able to clear customs through to the destination country. Again, it impacted in terms of movement of people. So on the project I'm talking about, the project had reached a commissioning stage. They were due to commission power station. And as you know, on these more complex projects, you have skilled resources, people who know what they're doing in terms of commissioning a power station, often not in the jurisdiction that the power station is being built. And these people were unable to get through, or nowadays, in the current times, it's all about whether they've had the vaccine or the tests, if they haven't had the vaccine, and whether they can clear the vaccine requirements in the departure country and the vaccine requirements in the destination country. Of course, in the simplistic case, it was more a case of delay. In the more complex case, it's more a case of disruption. Disruption being that not all site activities or not all activities on the project were affected by the said delay. Of course, disruption claims are more complex, way more complex than pure delay claims. When you have this sort of situation, what you need to demonstrate in a disruption claim is that the costs associated with the prolonged activities, and those costs may extend to site overheads if they're relevant, where actually the claimant needs to demonstrate that they suffered a loss as a result of those prolonged activities. And as you can imagine, when you're trying to pull out the activities that were affected together with the site overheads that go with those activities, in a claim, it can get quite complex, and you often see situations where the claimant may be submitting a claim around COVID, which sometimes by design, sometimes by coincidence, masks the underperformance of the claimant on other areas of the project. So these are some of the challenges that I've found and on delay claims around the pandemic in particular, Tom.
I touched on just a little bit earlier was this situation where actually things are getting so bad, perhaps because of the way that the risks have been allocated in your project, or just how the impact of COVID-19 has been felt, that one of your counterparties actually gets into serious financial difficulties, which puts you in quite a difficult position, particularly if you're in a JV. Because if you have a financially precarious JV partner, you're left with a difficult decision of, do you let them fall over? That could be catastrophic to your ability to perform. Do you de-scope some of their work? Do you give them more money? Mushtaq, how would you deal with that situation where your counterparty is in that kind of precarious position?
Thank you, Tom, and I thank ACL for organizing this great event. I think that there have been things that have been touched upon. Risk. Obviously, every contract will have risk, and the best contract will be the one which thinks of all the risk and creates a way of allocating the risk to the right party. But obviously, we can't predict everything at the time of contracting, and the contract becomes an imperfect document. Now, when you have the situation of financial difficulty of the counterparty, you still have to go to, as a first port of call, to that contractual document and see what is in there, what is provided in there. So if it is a question of de-scoping the works, maybe first see whether there's a contractual clause which allows for the de-scoping, and follow the procedure for the reduction of the scope of work of the contractor. So the employer, maybe if it has the means to carry out that work itself, or find somebody else quickly to do it, then it just follows the procedure and goes ahead with it. Alternatively, to have continuous monitoring of the project and dialogue between the contractor, consultant team, and employer, so that problems are spotted early, and if there are issues of financial difficulty, then you can have some sort of agreement amongst all those stakeholders in order to reduce the scope of work and find other ways of getting to the line with the project. More drastic options would be suspending the contract, but obviously not every legal system will allow for suspension at convenience of the employer. And also suspension of the contractor's obligations would have to be accompanied by something meaningful for the employer. So if the employer is thinking about self-help, the question is, where do you suspend unilaterally the contract and then go and do some part of the scope of works yourself? That's sort of a tricky line to tread, because if the employee is engaging too much into the contract, the contractor could turn and say, well, actually, you're doing my job here, and you're acting in a way which is akin to a termination or removing a substantial part of my scope of works, and this affects my economic model. So the employer has to be careful with suspension accompanied by self-help. And then even more drastic would be, and last resort would be termination. Again, I'm going to come to that a bit later on termination, but it is very important to look at what's in the contract and also what legal system the contract is being performed in, because sometimes you use standard forms such as FIDIC or JCT, but each country can have some very specific provisions about termination, and it's important to get proper advice on how to go about doing a termination of contract. There are other considerations, of course. There might be, other than the contractor, consultant team, and employer, there might be other stakeholders, such as banks who have provided financing, and they might have clauses in their contract providing for financial difficulties of one of the parties and an ability to step in. So the employer has to be mindful of those provisions and see whether, again, it comes back to monitoring, not just the contractor's obligations, but also the other contractual arrangements with the banks, to see whether are we getting anywhere near close to the step-in rights of the bank. And also consider whether there might be insurance claims that can be brought to insurers if there are things that no one anticipated, which is disrupting the contract. And then the final consideration I would mention is in a JV situation, if the JV partners are contractually towards a third party jointly and severally liable for commitments, then it might be an added incentive for the JV partner who's not in financial difficulties to step in and provide funding. Otherwise, it might be facing a much bigger claim in damages later on.
Very interesting observations there, and the different options which are open to you when dealing with a kind of precarious JV partner. Now, we're going to come back to the termination question a little bit later on, because that, as Mushtaq was saying, has some real complicated elements to it. But kind of regardless of whether your counterparty is kind of underperforming due to their financially precarious situation or other reasons, if they are in serious delay and that's putting the project in delay, are there any strategies, Sena, that you might deploy to try and get them back on track?
Yeah, there are, and well, with all of these, with the strategies I'm going to talk about, there, some of them are not provided for contractually, so it's all about the parties wanting to engage in these strategies and get a contract back on track. Fundamentally, in order to do anything about delay or disruption, you first need to understand the causes of delay. The problem often lies in identifying the root cause or the trigger for the delay, because that obviously points to who is responsible for it. Sometimes it may be clear-cut in a JV situation. Other times it may not be, and there may be disputes within the JV itself about the causes of the delay. However, once you've identified the causes and understood what they are, you can then decide what to do about them. Now, for most delays, you may either want to mitigate or accelerate. The distinction I like to make between mitigation and acceleration is acceleration requires extra funds, extra resources, whereas mitigation may not cost that much by way of funds. So, like for instance, resequencing. And the JV may decide mitigate acceleration, or indeed to make an extension of time claim whereby the completion date is extended, and by extending the completion date, you avert or you push the LDs down the line to the new completion date. On one metro scheme I was involved in, the scope was to build, equip, commission, and operate a new metro system from scratch in an existing city. The scope included 40 miles of new track, tunnels, and the provision of new systems such as power signaling, and of course the rolling stock, the trains. The JV was made up of a civil engineer, mechanical engineering specialist that was doing the infrastructure, and a train manufacturer, a rolling stock manufacturing firm. The infrastructure became severely delayed because they ran into all sorts of issues. In this particular case, existing city, there were lots of services underground and in doing all the groundworks, and that meant that the milestones on the overall contract, which is provision and testing of and commissioning of the trains, were delayed. As the train manufacturer had skin in the game, as it were, in that it would be missing, it would also, the JV as a whole would be missing the milestones, the commissioning milestones of the rolling stock. LDs would be applied, and my involvement there was to help resequence the program and achieve that by effectively overlapping the civil and infrastructure completion dates with the start of the rolling stock testing on the network. Obviously, it required the two JV partners to agree on the overlapping, on the resequencing, which was an additional agreement on top of the JV agreement. But in this particular case, they worked out that would be the best thing for the JV. It was amended and agreed by both parties. So there are all sorts of ways that you can actually try and bring a project back on track. It does need a fair degree of cooperation, and sometimes may need some additional funding. We've already heard about how funding can actually break up or cause problems in the JV itself. But all things being equal, it does need a fair bit of funding by the JV partners to bring this to fruition.
I think we may have lost connection.
Okay.
Now, as I'm sure a lot of you will be aware, kind of termination is quite a nuclear option. We typically say to any of our clients who are considering termination, don't terminate, unless you're, just don't terminate normally, but unless you're really, really sure of what your termination rights are and you've made sure you've put in every single notice. And the reason I say that is because under English law specifically, if you purport to terminate a contract and you're not actually entitled to terminate that contract, the other party can view that as what's called a repudiatory breach. A repudiatory breach is a breach that entitles your counterparty to effectively elect to terminate that contract themselves. And then you, rather than being the party terminating somebody else, suddenly find yourself being terminated with all the kind of liabilities and costs that go with that. So it's a very delicate situation, but it can be a very strong tool in your kind of arsenal for dealing with a poorly performing counterparty if it's used correctly. Now, I mean, if you are considering termination, again, I apply a big health warning on this. First of all, it's kind of imperative that you have a very full understanding of what the contract says and what steps you need to go through. And it's imperative that you follow each and every one of those steps, particularly where it comes to the issuing of notices, that you've got absolutely everything right. And not only do you need to kind of get I hesitate to call it the paperwork, but the paperwork element of things right. There's a huge amount of practical considerations you need to take into account when you're removing somebody from a live project. I mean, just to give you an example, so the project on which we terminated the main subcontractor was about 50% of the way through. The contractor was a civils contractor. They had poured most of the foundations. They were busy on erecting steelwork. You know, it was a delicate time to remove them from site. In order to make this work, not only had we stacked up all of the contractual obligations some months previously, we had been sending our notices, we had been giving them opportunities to remedy breaches. But what we also had to do in the background was ensure that we could take over their supply chain to make sure that we had an hour-by-hour plan to how we actually remove them from the site, given they have, 150 people running around and all of their equipment. What are we going to do with that equipment? What are we going to do with their materials? What about the critical equipment that have been ordered by them but not yet delivered? How do we handle all of that? Now, to some extent, operating in the way that you should always be thinking about the worst, having a contract which provides for this is your best option. So do you have a right to take assignment of their critical subcontractors and supply chain? If so, how is that affected? Do you even know who those suppliers are, and do you have contact details for all of them so you can do this quickly? Those are the kind of things you need to bear in mind. And also, like I say, having this kind of hour-by-hour plan for how you're actually going to affect it is really important. And also, if there are multiple options for terminating, multiple grounds for terminating, can you put yourself in a position where you've actually able to engage 2 grounds of termination or even 3, such that the risk of you being found of having terminated incorrectly is reduced because you actually say, well, if I'm wrong on this ground, I'm right on the other ground. So, that's the kind of practical considerations you need to bear in mind. And despite us having laid this out for some months previously, the actual termination still came as a surprise to the subcontractor. We still had to employ security on site to effectively lock them out. We then had to take them to court to get injunctions to make sure that they properly assigned their supply chain. And some of the unexpected bonuses of this is when they walked out of site, they left all of their site paperwork, which under the terms of the contract became our paperwork. So we suddenly had a great insight into how they'd actually been running the project, which threw up all of these problems which we weren't even aware of, which we could then use for our claim for additional cost at the end of it. But I use that just by way of example of termination being the kind of nuclear option for when your counterparty is not performing. Now that was an example of how you might, what kind of considerations you might need to have in mind under an English law contract. But Mushtaq, you said earlier, you know, that there's lots of differences and particular elements of local law, I think particularly in civilian jurisdictions, that can provide additional hurdles to termination beyond just that kind of risk of repudiatory breach. I mean, can you give us some examples of those?
Yes, of course. Most civilian jurisdictions the contract law will be provided for in a civil code inspired from 19th century French law. Now, in the original version of the civil code, and that is a provision that carried on for decades in France until they had a reform in 2016. But many jurisdictions like Mauritius have kept the old wording. So you have a provision in the code saying that a resolutory condition, so that's a kind of term that if it's broken, the contract can be put to an end. That is always implied into a contract. And the innocent party has the right to elect whether to force the other party to perform the contract or to claim damages. But if the innocent party chooses to terminate, the code tells us that can only be ordered by the court. So you have to go to court to get an order allowing you to terminate the contract. And the judge, even then, the judge can consider whether it's better to give additional time or whether to order the termination. It is true that that is the kind of harsh starting position in the code. But as time went by in jurisprudence in both France and in Mauritius, which has followed that jurisprudence, some exceptions have been allowed. So for the first one is termination clauses. They have been recognized in both countries as being a valid exception to Article 1184. But the courts are very, they will scrutinize whether the formalities of the termination clause have been followed. So for example, if you have a requirement to serve notices, they will scrutinize whether those notices have been sent. And when, they will scrutinize the contents of the notices and see whether they are in accordance with the contract. A second exception that has been allowed is, it's in French you say exception d'inexécution, and that broadly means that if your counterparty is not performing, you have a right to suspend your performance. So if the contractor is not being paid by the employer, they can stop working, or vice versa. So that doesn't help moving the project along because you're just withholding your performance. And then the third exception that has been allowed is unilateral resolution of the contract, meaning that if there's a situation of urgency where you as an employee, you don't have any other choice because otherwise you're going to be facing huge damages claim from third parties, then you can terminate the contract at your own risk and peril, but the contractor can have that decision re-examined in a court or arbitration as to whether it was reasonable to terminate. Ultimately, I think it is important that even the standard forms are used, and we are all familiar with the different clauses, and they are used across jurisdictions. It is also important to get advice as to what the local jurisdiction law provides as to termination, because if you get that wrong, no matter what's written in the contract, and you have a court or arbitrator saying, well, let's say Mauritian law was applying to a FIDIC contract, and although the FIDIC contract has got termination provisions, but still you should have followed those additional requirements of Mauritian law, then you might be in trouble yourself for having terminated the contract, even though there was a defaulting contractor. So those are things that you have to take advice. Tom, you mentioned earlier about having a plan for termination. So if you're minded to consider termination, what is your plan B? But another way of looking at this is if it does come out in a cross-examination in court or arbitration that you were contemplating that plan B, sometimes it can be turned on the party terminating, saying, well, if you were considering all that, it means that you are already minded to terminate the contract, and whatever correspondence you were sending about sending notices, they were just, you were just following the form, but in fact, you had already made up your mind to terminate, and all the correspondence that went on was made in bad faith. And so the argument of bad faith can be used against the employer. In some civilian jurisdictions, like France or Canada, although Mauritius kind of follows that, the Canadian approach, I don't know about other African countries, there's a concept of abuse of rights. So even though you have a contractual right to terminate, it's still open to a court to consider whether that right was exercised disproportionately or out of bad faith. And that in itself could be a tort, and the court could award damages for abuse of rights, even though you have the right. So it is important to understand those intricacies of local law and to get the advice before embarking on that nuclear option of termination.
Obviously, dispute boards have been around for a long time. They're in the 1999 FIDIC forms. They've been rolled out, across all the 2017 FIDIC forms, particularly the kind of standing DAB, where you have kind of a set of effectively dispute board members who are in place supposedly throughout the whole project. Now, let's say it's been around since 99 and a little bit before that. But historically, what we've seen is employers particularly, but also contractors, just striking a line through those clauses. They see them as a waste of time, a waste of money. Why go through a dispute board process with all the cost that entails if at the end of it you're going to end up with a decision which the other party is just going to say they're not satisfied with, and you're going to have to go to arbitration anyway? Like that I think is has been previously the kind of accepted view of dispute boards. That I think is beginning to change. And I think actually people are now using dispute boards as a way of unlocking these disputes, and they're using them as a way of getting a good enough decision in order to move the project forward. Now, there's a couple of elements to that. One part of that is parties are kind of lawyering up more for dispute boards where they are in the contracts, and the dispute boards are turning up more because a lot of the kind of financiers are basically saying you must use them. But what happens is parties are lawyering up, and we're seeing dispute board referrals which are basically mini arbitrations, or not even mini arbitrations, just full arbitrations. They've might have 10 witness statements. They might have 4 different types of expert report appended to them, and they're really big, complex beasts. But the upshot of that is at the end of it, you get a decision which you can have a reasonable degree of confidence is more or less what you're probably going to end up with in arbitration. So at least it allows the parties to kind of get a result, try and enforce it between them and move on with things. So that's what I'm seeing from where I'm sitting in London, looking at the kind of work which we're instructed on. But Abimbola, I'm really interested to get your views. Are you seeing dispute boards being used, or are you still seeing parties go straight to litigation and arbitration?
Thank you very much, Tom. We've not really seen much in terms of dispute boards in Nigerian practice. Arbitration remains a popular feature in most of construction contracts that we've seen. And whether it's a construction contract based on FIDIC, the FIDIC form, or the JCT building contract, we see more of arbitration clauses. And I've been involved in a construction contract that was a FIDIC 1999, the Yellow Book FIDIC contract. And there was a provision board, but it was a DAB. That's a dispute adjudication board. And it was a precondition to pursuing any claim before either party could proceed to arbitration. And we acted for the contractor, one of the largest construction companies in Nigeria. And it was the construction of a cement plant somewhere up country in Nigeria. And the contractor's claim centered on non-payment of a significant sum that had already been set owner's cost consultant while certified for payment. The owner had a counterparty claim for defective work. However, the DAB, our experience was the DAB unduly elongated the recovery process for the contractor, because the provision specifically requested that even though a third party could appoint the DAB, the appointing authority must also consult with the parties during the appointment process. And of course, you guessed right. The employer took advantage of the first took forever to agree, ended up not agreeing, and then the contractor then appointed the DAB, and the owner at every turn rejected the proposals by the appointing authority. And when the DAB was eventually constituted, the employer challenged the DAB's constitution and its jurisdiction on the basis that the appointing authority had appointed a candidate which they had concerns. And they then refused to engage with the process. And we went on to arbitration. And then the contractor turned around in the arbitration to say, oh, there's a DAB in place. And we couldn't proceed to arbitration because the arbitral panel was ICC. Came back and said, well, you haven't fulfilled the condition precedent. So it was a real catch-22 situation generated by the employer to frustrate. So what we have found, though, is that DABs offer benefits when the construction project is ongoing. And invariably, both parties are interested in seeing that the construction continues. I find that, from my reading and experience, that's when DABs tend to, or dispute boards tend to work. But when the construction is completed, it gives one person the advantage to be very, very difficult. And it turns out the best way to go after that is arbitration. And that has been our experience. Arbitration remains the most popular means of resolving these disputes, in my experience. And I think most Nigerian lawyers. And another reason why that would be the case is, in Nigeria, there's no statutory provision, recognition, or position for dispute boards. So enforcement, if you get an award or a decision from an adjudicator or a dispute board, enforcing it would mean you either take it to arbitration to enforce, or you go to litigation to enforce. Whereas I think in other jurisdictions, the decision of a dispute board can be enforced. So I think that might be the challenge that we're experiencing here.
Yeah, absolutely. And that difficulty of effectively having to go to arbitration to get the decision enforced then depends hugely on the jurisdiction in which you then need to enforce that decision, because many jurisdictions will simply not recognize what they see as a partial award, because it's an award by a tribunal that may be reconstituted in order to determine the case on its merits if the other party serves a notice of dissatisfaction, which they almost inevitably will if you're dealing with a party who's trying to resist enforcement. I agree there are problems, but as you say, I think during the course of the project, they can be great at unlocking disputes. And also what they really do is they avoid the situation which happens at the end of a project where the parties are incentivized to throw in absolutely every conceivable claim or counterclaim into the arbitration, which is why we end up with these absolutely enormous construction engineering cases. I realize we're right up to the hour, but I just want to give Mushtaq, now I'm going to say 30 seconds, maybe 45 at a push, Mushtaq, just to give us some comments on, in the real difficult situation where your counterparties actually become insolvent and you've got outstanding claims against them, what do you do about that, Mushtaq? Can you arbitrate against an insolvent party? Would you want to?
Yes, certainly you can. I think there would be two categories of considerations. First one being commercial. I don't know if you can still hear me. I see I've lost connection. Can you hear me at your end, Tom?
End our session there.
Tom, can you hear me?
I'll go out to the audience first. Just don't know if anybody has any questions on that whistle-stop tour. Yes, we've got some, lots of questions. Excellent. Great. I think somebody should be circulating with a microphone. Maybe I'm looking at. Thank you.
Yes, thank you. I'm Gideon Kamiel Koda from HKA. You did mention DAB, Dispute Adjudication Board, and I'm sure, Tom, you're aware of dispute avoidance boards.
Sorry, I didn't quite catch that.
You are aware of dispute avoidance boards.
Yes.
Now there is a term dispute adjudication boards, and you're also aware of adjudications. Are you able to clarify for the audience the differences between the three?
A dispute avoidance board, which obviously is part of what, yes, so FIDIC implemented in the 2017 kind of redrafting of the agreements, is designed to have hands-on approach during the project. So the parties can refer to the dispute board who's a dispute to them for a non-binding recommendation, which is effectively like an independent outsider's view on what the parties might want to do to overcome the dispute that they're currently in or the situation which they're currently in. The FIDIC forms also have got that quite interesting element whereby the standard avoidance board, the DAAB under the FIDIC forms, confronting dispute proactively suggest to the parties that they refer a dispute to the dispute board, which is actually quite an interesting thing when you think about it, because that's effectively the dispute board members looking over, tapping them on the shoulder and be like, excuse me, I think you've got a problem. I think we should be helping you, but the mechanism requires them to then refer it. So I think in theory, the DAAB under the FIDIC board thing, it makes a lot of sense. I think parties don't want to pay to have a standing board of people who are just kind of reading into the project and trying to understand and suggesting things. Parties don't like third parties kind of meddling in the project either. Nobody likes that idea. Everybody feels like they can run it themselves. So the DAABs we only tend to see on really big kind of mega projects, which are publicly funded, often by development banks, who impose that process. Now, one thing which I was at another conference a few weeks ago, there was a lot of dispute board members there, and I don't know whether anybody in the audience today is instructed on a dispute board. If you are, cover your ears, because what I heard was that in the market, there are lots of parties who are basically saying, right, great, we will have a standing dispute avoidance and adjudication board, but we're not going to pay the standing dispute board members for any of the work they do unless the dispute is referred to them. And at the moment, it's quite competitive to get appointed to dispute adjudication and avoidance boards, particularly because a lot of the people who get appointed to them are really interested in the avoidance side and want to make it work, that they are accepting non-payment for the period during which they're standing. So suddenly that cost element, you can hopefully remove that. And then I think things get a bit more interesting. But yeah, I think that the main difference between the avoidance and the adjudication is the issuing of the binding decision, binding initially and then final and binding if no notice of dissatisfaction is issued. The avoidance element is that kind of slightly proactive but also responsive kind of non-binding recommendations which are intended to kind of keep the project on track. Sorry? Oh, adjudication on its own, yeah, of course. So adjudication on its own, not through a dispute board, is typically a statutory element in lots of jurisdictions. I mean, it's come up through the UK for many years now. It's in Australia, Malaysia, Singapore. It's got its footings in legislation. If you get a dispute referred to an adjudicator, it's a very short form process. In the UK, it's just 28 days from the referral of dispute to getting the decision. That decision is then interim binding, but it's enforceable in court. which means that you get, it's basically a kind of pay now, argue later process, which is very well grounded in law, so avoids a lot of the problems which Abimbola was talking about, which is where you end up with this decision which can be effectively meaningless.
So, hello. We have seen, I'm pretty sure that there is not a white and black answer, lots of grays, but we have been experiencing a couple of projects claims due to COVID, but that when COVID happened, the contractor was already in delay. So if it had not been in delay, he would have not been caught by COVID and then the crisis. Any thoughts on that? How to make it work?
That's an excellent question. I was just about to look to Sena, but he's gone. So I mean, I think you need to look at the impact of the delay at the point in time in which it's felt. So the fact that work is still ongoing, I think, as a starting point, doesn't mean you can say, well, if you weren't in delay, you wouldn't have suffered the impacts. But it does come into the overall calculation of what what costs should flow from that. And again, I'm going to give a terrible answer, which is very fact specific. But it's very fact specific. And I think the end point is it would be nice and neat to say, well, but for your original delay, you wouldn't have felt the impacts of COVID. I don't think that's going to fly in my own experience, but I'd be very happy to discuss that over lunch more if anybody's got different views.
Thank you. My name is Ozioma Ago, and I'm a lawyer with Aluko and Oyebode. So my question is on the relationship between a head contractor and a subcontractor, because I've worked on agreements where conflicts arise between these two people, and it can be in two ways. First, where there is already an existing contract between a head contractor and the owner, and they've already signed this contract. And now you have a head contractor who wants to push all the risks to the subcontractor. And the subcontractor is saying, no, I'm not agreeing to this because, and then the head contractor is refusing because this was not factored in the contract price, which he had already agreed with the owner. And then we also have an agreement, an EPC, for instance, where which I've worked on, or which I'm working on, which is tripartite between the owner, the head contractor, and the subcontractor. And this is kind of easier because all the parties are together and they are negotiating these things. But again, the issue still arises because the subcontractor does not really have a lot of provisions applying to it directly, even though this is tripartite. It's the major provisions are between the owner and the head contractor, who now goes on to enter into maybe subcontractor appendices with the subcontractor. But you still have that issue coming up. So how do you open renegotiations which have already closed, right, with a subcontractor who is unflinching and does not want to be, to incur losses? Yeah, thank you very much.
It's a very, very difficult situation. One I have been in myself when I was in-house, when we had negotiated everything and the subcontractor then said, well, I'm not taking that risk. And you get left with gaps. And it's actually in an ideal world, the main contract and the subcontract would be back to back and you would flow everything down. That ideal world very rarely comes to pass, mainly because subcontractors at the bottom often can't bear that amount of risk. They can't cope with that amount of risk. They can't offer the prices that you need them to offer if they're going to take that risk on, which just leaves you with a gap. Now, unless you can force us on, that gap is going to remain with you, the head contractor. And that is going to be something which you're going to have to make provision for in your accounts. And it's a stressful position to be in, particularly when that risk eventuates. So how do you reopen the negotiations? But you need to incentivize the subcontractor with something. Now, what that something is depends on the particular project, the relationship between you and your partner, relationship you might have with the employer. What I've seen in the past is head contracts going back to the employer and saying, there is a gap, I cannot deliver your project because of this gap, and I can't find another subcontractor in the market. We need to work together, if the relationship is good, head contractor and employer, to reallocate this risk, to share that risk. Right? That sometimes works. You can share the risk with the employer. If the employer says no, let's face it, most employers are going to say, no, I've signed the contract, it's your risk, you deal with it. Then you're going to need to find something to incentivize a subcontractor to take on more risk. Now, first of all, you can look to the insurance market, see if you can price that risk. You might be able to price the risk. There might be a kind of a dollar, naira amount you can put against it. Maybe you and the subcontractor can buy it out with insurance policy. Again, that's difficult because often these risks are uncertain and difficult to place with the insurance market. So then you need to look and see, what does a subcontractor want? What does a subcontractor need? That could be as simple as other projects, invitations to bid for other things. You might find that some subcontractors are receptive to that. Or alternatively, can you give them some flexibility around completion dates, relief from LDs? Can you keep this in your pocket, and later when they're really struggling on delay or something, can you offer them, if you've got enough float in your contract, in your schedule with them, can you offer them relief from LDs in relation to an amendment to the contract later down the line, which then says they will cover that risk if it eventuates, which again obviously only works if the risk is not then eventuated. So, I mean, that's a load of ideas, none of which answer your question, I think, because your question is so difficult. And if it was straightforward, we would all know the answer. I don't know. Again, I would be really interested to hear from people, either now or over lunch, what other strategies have worked in that situation, because it's something which I'm sure you come up against all the time, and I've seen a lot, and it is a really, really tough negotiation because the documents are signed and nobody wants to take additional risk after the money's been agreed. Okay, great. Well, thanks very much. I've really enjoyed this. It's been a huge privilege to come and speak to you, particularly given how packed out the room is with so many kind of esteemed and high-profile guests. So thank you very much. And Abimbola, thank you for joining me, and my panelists again. Thank you all for joining. We've had a great time.
Please, a round of applause for them.
Thank you.
Thank you so much, Tom, Leonard Silk, Sena, Mushtaq, and Emilio. I know we still have many questions. Tom and the Leonard Silk, I believe you'll be joining us for lunch. So please ask them questions over lunch. Don't let them eat their food. We can pump them with questions at that time. For Mushtaq, Sena, and Emilio, I'm sure they'll be happy to answer any questions. So please drop them a line if you have any questions for them. In terms of next steps, I'm hungry. If you're not hungry, so please let's just proceed to the next room and grab some lunch. We'll break for 45 minutes, 50 minutes, so that we can start at 3. Thank you very much. See you soon.
Thank you.